Namaste, welcome in this channel. I'm Officer. Our topic today is types of law, classification of law, kinds of law, division of law. Don't be confused on these words. So these are similars. So in this topic, mainly we focus on substantive law, procedural law, what is civil law and criminal law, what is public and private law, what is federal law and local law and state law also. So possible question, what are the different classifications of law? What are the classification? What are the types of law? It is very common questions, very common curious. So look at in this chart law. Firstly, law divided into state or national law, international law. Then national law divided into public law, private law. So public law also divided into constitutional law, administrative law, and criminal law. So national law divided into the private law, and private law also divided into law of person, law of property, law of obligation, and the conflicts of laws. And also the law of obligation classified into contract law, quasi-contract law, and tort law. This is the main classifications of our law in understanding. Okay, so types of law, very common word. Law is used in different senses in the different condition. The use of the term law is made various in senses. It denotes different kinds of rules and principles. So what is law? Law is the body of rules, body of principles that determines our behavior, state behavior, and organizational behavior, right? So in this slide we mainly discuss on the substantive law and procedural law, civil law and criminal law, public law and private law, national law and international law, constitutional law and administrative law, and others law, commercial or business law, mercantile law, contract law, law of torts, environmental law, and finally family law. So in total, how many laws? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 laws. Yes? So substantive and procedural law. By this word, look at here. Substantive means substance, the law related with the substance, certain things, certain rights that may relate with the substantive law. Procedure. So procedure means law follows certain procedure to give justice, and the law related, the process is called procedural law. So look at here. The law which defines rights and liabilities is known as substantive law. Very clear. Law that defines what type of rights, what are the rights and liabilities. So law focusing on rights and liabilities is known as substantive law. It is called so since it lays down a proper and precise substance of subject matter which is enforceable in the courts. So the purpose of the law that is substantive is to define, create, or confer a proper substantive legal rights or status, or to impose the nature and extent of any sort of legal duties and obligations. The purpose of substantive law is to define, create, confer proper legal rights, legal status, and legal impositions and legal duties. So substantive law mainly focus on the rights and duties of the people, rights and duties of the person. Clear? Substantive law, with regard of specific subject, defines the legal rights and relationship of the people between themselves or between them and the state. So, relationship between state, relationship between peoples determined by the substantive law. Any wrongdoing of an individual, group of persons, or the state against another will hold him liable to others accordingly for the purpose of any substantive law. The wrongs could be either civil or criminal. Substantive law refers all forms of law, both public, private, including the law of contract and property, torts, and criminal crimes of all kinds. So, these all laws fall upon the substantive law. So, by seeing this model, substantive law has more and wide scope, right? So, another law, procedural laws, procedural law. What is the procedural law then? Procedural law, look at here, procedural law. So, procedural law, the law of procedure is that branch of law that deals with the process of litigation. So, procedural law totally deeply related to the process of litigation. Litigation means process of cases, partition case, criminal case. So it is strictly related to the process of litigation, how to get justice by the victim, by the aggrieved. It consists the rules and procedures pertaining to the institution and prosecution of any kind of civil or criminal proceeding. So, prosecution process that takes steps taken by the institution consists the procedural law. Procedural law consists of a set of rules by which a court hears cases and decides the proceedings. So, who hears the cases? Who resolves the cases? Court, Supreme Court, High Court, District Court, Trial Court, Judicial Committee of the local body hears the cases. So, what type of process, what type of step follow that tells by the procedural law. Historically, the law that many know is substantive law, and procedural law has always been a matter of concern only to those who preside over the judicial officials or those advocating law. But over a period of time, the courts developed a system of evidences and procedure that fall within the purview of the procedural law relating to the fairness and transparency of such process. So, in the history, only court officials, only advocate must know to procedure. It is assumed. But now, each and everybody must know about the procedure. Why? Because fairness, transparency process must be known to the people for the fair justice, for the proper justice. Then, what are the examples of the procedural law? Look at here. Evidence Act. It is the example of, it is the law that is totally related with the procedural law. The Code of Civil Procedure, Civil Code Procedure, the Code of Criminal Procedure are example of the procedural law, right? Then another law, look at another law, that is another types of law is civil and criminal law. Civil, by this word, it is totally related to the civil people, citizens. It is totally related with the just civili. Just civili, that means civilians. So law related with only civil people, only general people, only citizens, that is fall under the civil law. And another criminal law, crime, the law related with the crimes. That means law related with the criminal activities is law related with the criminal activities. So criminal law, what is the criminal law? Means then the crime, criminal law defines the crimes and prescribes the punishment. So more detail, the civil law deals with the private means general peoples. The civil law deals with the private rights and duties which arise between the individuals in a country. So some rights, some duties arise between the individuals. So civil law deals with the grievances, or it deals with the conflict between the only individuals, peoples. So it is only related to the private rights, private duties. Yes, the object of civil action is to correct the wrongdoing that has been committed. Object means main aim or goal of the civil law is to actions to correct if wrongdoing happens. So enforcement of civil law is the accountability of the individuals who has committed the wrong, and the state is responsible to provide for the procedure to resolve the disputes. So in the civil law, state only play the role of remedy, or state only play role of the what repairing the justice. In the case of civil proceedings, the person who claims suits means petition cases, the defendant in civil court and asks for the remedy. So in the civil law related issues, only general people, only civil people file the cases in the court against the another civilian. So main aim of the civil law is to remedy the civil rights, right? Then criminal law, look at here, criminal law. Criminal law defines offenses and prescribes the punishment for them. Look at here. Defines offenses, defines crimes. What kind of activities is crime? For example, heinous crime all over the world. That is defined by the criminal law. And punishment, 10 years to 15 years, life imprisonment, such kind of punishment also prescribed by the criminal law. Its aim, its goal is the prevention of the prevention of and punishment for the offenses. The main aim of the criminal law is to prevention the crimes and punish the offenses. Criminal law is necessary for the maintenance of order and peace within the state. So maintaining the peace and order, it is the main aim or necessity of the criminal law. In civilized society, crime is considered to be wrong, not only against the individual who has been wronged, but wrong against the society. In civilized society, crime is considered not only wrong against the individual, but wrongs against the state or society. Therefore, look at here, important point. Therefore, the state, that means federal government, initiates the proceedings against the offender, and thus it is always party in the criminal cases. So state party cases, government party cases, it becomes. Why? Because it is crimes against the society, crimes against the state. This is why the criminal law is considered as a branch of public law. Right? What is the criminal law? It is also branch of the public law. Then look at other types of also law, public and private law. Then what is the public and private law? Public law, private law. Very simple. Public law public law means government law. Government law means it is related with the government official, or it is related with the formal organization, formal branches or bureaucracy. And private law, it is related with the only citizenship, only private people, only individuals, only persons, right? Then public law, look at here. What is public law? By this, looking this word, the law which regulates the relations between the individuals and state is the public law. Very simple. The regulations between state and individuals is the public law. That means public law regulates the relationship between individual and state. It is made and enforced by the state on behalf of the community. So public law made by the state on behalf of the community. By state made the law on the interest or the will of the community, depending on the will of the community. Public law stands subdivided into three categories. So how many categorization what is the division of public law then? Look at here. Constitutional law, the main law of the land. Compulsory, what is the constitutional law? Main law of the land. It prescribes the organization of the states, functions, power and duties of the state organisms. It advocates about the separation of power, that is constitutional law. Administrative law, look at here, we discuss in this slide also administrative law, criminal law. And private law, this is the branch of law, regulates and governs the relationship between citizens with each other, only related with the individuals. The parties in such case are private and individuals. The state, through its judicial organ, adjudicates, means gives the matters in dispute between them. Only judicially gives the justice in the private law. In the classification of private law, there is a great difficulty. Different jurists have given different classification, a very general classification of private law. Look at here. Law of the persons, that is related with the personal law. Law of property, law relating with the property, will, interest, so personal property, personal skills property, that may be the law of the property. Law of obligation, numbers of duties prescribed by the law, numbers of obligations, or number of compulsory liabilities prescribed by the law, that is law of obligation. Conflicts of law. The law of obligations is also divided into three classes. Contract, look at law of obligation is also classified into contract, quasi-contract and tort. Then national and international law. National law related with the state territorial law, a law that is applied within the state, within the territory of the state. National law. International law, the law that relates the nations. International, that is international law. Look at here, national law, the body of rules which regulates the actions of the people in the society, and it is backed by the coercive power of the state. National law is the law by which people are governed by the state. It stands classified into several kinds: constitutional law, ordinary law. So national law, territorial law. Clear? International law, that is the body of rules which guides and directs the behavior of the states in international relation. It is a law among the nations. So what is international law? Laws among the nations. That means that laws which governs the international countries. So relations between Nepal and China and India governs by the international law. Relations Nepal with America governs by the international law. Clear? The legal process that concerns legal relation among the nations is called international law. The United Nations is of the primary mechanism that articulate or create international law. So United Nations is the main sources of international law, or it is the organism, or it is the mechanism to create the international law. The major sources for international laws are multilateral treaties, international customs, general principles are recognized by the civilized nation. Mostly treaties, declarations, human rights declarations, covenants, United Charters. These are the sources of international law. Then look at constitutional and administrative law. By words, constitutional law, very familiar. Constitutional law is the supreme law of the country. It stands written in the constitution of the state. The constitutional law lays down the organizations, power, function, and interrelationship of the three organs of the government. It also lays down the relationship between the people and government, as well as the fundamental rights and duties of the citizens. It can be called law of the laws in the sense of all lawmaking state. Look at here, law, constitutional law, called the law of the laws. That is the main law of the laws. The father law of the laws is the constitutional law. Then administrative law, look at here. It lays down the rules governing the exercise of the constitutional authority, which stands delegated by the constitution of the state to all organs of the government. It also governs the relationship between civil servants and public, and lays down the relations between the civil servants and states. In some states like France, administrative law is administered by the administrative code. General law is administered by the general code. Very similar. Administrative law, it is law that is related with the relations, that governs the relations between the state authority and peoples. So the law that governs state organs, one ministry to another ministry, that is administrative law. So whole state administration systems related laws are administrative law. Clear? Then federal law, state law, and local law. So Nepal is a federal country. So what is the federal law? Constitution clearly prescribes the law that is related with the Schedule 5, Schedule 9 of the Constitution related with the federal law. State in Nepal, there were seven states that state assembly, province assembly also make the laws, that is state law. Local law means municipal laws. Municipality make the law, village municipality also make the laws, that is local law. Clear? Federal laws are rules that apply throughout the country. So federal law applied within the territory of the country. These law applies in the every state, such as immigration law, law relating to immigration, passport making, passport checking. So these laws, immigration law, bankruptcy law, bank and financial institution of the country governed by bankruptcy, banking laws. These are the federal laws. Social security, supplemental security incomes laws, social security laws, labor laws. These are also federal laws. Federal criminal laws, such as law against the tax fraud, counterfeiting of the money, all criminal activities also fall upon the federal law in Nepal. There are states within the country. In Nepal, there are 7 states. In the India, there are 32 states. So each has its own system of law, welfare, public assistance, medical matters, wills, inheritance, estate. These are issues fall upon the state law. In Nepal, health and safety also fall upon state law. Educational, road making, city making, industrialization, industrializations, so environmental issues, development issues, these are made by the state. These are the state law. And look at the local law. There are different metropolitan cities, sub-metropolitan cities, municipalities, rural municipalities. In Nepal, 753 local bodies. Some of them have their own system of laws. So own system of laws and codes that handle building codes, zoning codes, local safety, taxation, local registrations. These are fall upon the local law. Others are, look at here, business law. Business law, that is related with the mercantile or commercial issues, refers to the laws that governs the dealing between the people and commercial matters. There are also distinct business law, relationship commercial entities through the relation, partnership law, company law, bankruptcy, agency. These are the business law. Contract law, agreement, enforceable agreement is a contract. Then contract law is the body of law that relates to making and enforcing agreements. A contract is an agreement that a party can turn to court to enforce their agreement. A contract law is the area of law that governs making contracts, carrying them out, and fashioning a fair remedy when there is a breach. If the contract is violated, if contract is breached, and then how to repair, how to perform the contract, that is governed by the contract law. Tort law, tort is small type of obligation, small type of crime activity. Tort law is the area of law that covers most civil suits. Generally, every claim that arises in civil court, with the exception of contractual disputes, falls up under the tort law. The concept of this area of law is redress wrong done to person and provide relief from the wrongful acts of others. So reparation, restitution, compensation fall upon the tort law. Clear? Others law, look at it. Environmental law, that law collection of laws, regulation and agreements, and common law that governs how humans interact with the environment. What type of relations humans with the environment. The purpose of environmental law is to protect environment and create rules for how people can use natural resources. So, environmental laws not only aim to protect environment from harm, but they also determine who can use natural resources and on whom, on what terms. Laws may regulate pollution, the use of natural resources, forest protection, mineral harvesting, and animal and fish population. These all fall upon the environmental law. Family law. Family law is a legal practice area of focus on issues involving family matters, relationship, divorce, father-mother relationship, such as adoption, divorce, child custody, among others, partitions, partition case, very familiar in our society. These are family law. Attorneys practicing family law can represent client in family court proceeding. In Nepal, district court, general court also hears the family law related case. Some family law attorney even specialize in adoption, paternity, emancipation, or other matters that are usually related with divorce. Okay, this is my channel. So in this channel, ignorance of law is no excuse in general law. So law must be known by the all. Please subscribe this channel. Thank you listening to me. Okay, thank you.